our final panel of this two-day conference. My name is Michael Weibel. I'm a visiting professor at Harvard Law School this semester, and I'm delighted to be chairing this panel. We've agreed that we would keep this panel very interactive, so I'm going to ask our panelists a series of questions. And let me just very briefly introduce them to you, starting from your left. We have Preti Bhagnani, who is a senior associate at White and Case, followed by Narcis Torres, who's the founder and CEO of Lex Finance, followed by Dana Mcgrath, who is at Bentham IMF, and then finally Isabel Yang, the founder and CEO of Arbitration. To get us started, I wondered whether each of you could tell us for a minute or so how you came to the world of arbitration finance. So tell us a little bit about your background and what led you to your current role. Starting with Preti.
Sure, thank you. So I've been practicing international arbitration for several years, initially in Singapore and now in New York. And as counsel, a mix of investor state and commercial cases. And in the last few years, my experience has been, there's been a surge of third-party funders, and so we now have a couple of cases, both commercial actually, where they're funded by third-party funders. So very much in the midst of all of it, and happy to talk about my experience.
Great, thank you. Narcis.
Sure, I am a lawyer by training, and after working for many years in investment banking and asset management with a group of friends, we set up a local asset manager first in infrastructure projects. But 4 years ago, we decided to go into this new asset, and in such a way, we decided to focus first and only in Latin America, Spain and Portugal, and secondly, only in arbitration financing.
Great, thank you. Dana.
Good afternoon. My name is Dana Mcgrath, and I'm with Bentham IMF. My background is that I spent about 20 years in the role of counsel in the field of international arbitration, most recently with Sidley Austin in their New York office in the international arbitration practice. I was also with Allen & Overy in the arbitration practice and O'Melveny & Myers. And so I've seen arbitration from a couple of different vantage points from the law firm setting. And I joined Bentham IMF in January of 2019, so I'm one of the newer joiners to the funding industry, and it's been a very exciting start. I love what I'm learning, and I'm really excited to be doing this. And I have some perspectives as a new joiner. And I look forward to this dialogue with the panel.
Hi, I'm Isabel Yang, founder and CEO of Arbitration. It's a predictive analytics startup I picked up over the past 2 days. That might be a controversial term here. But I'm a statistician, economist, and lawyer by training. The reason I got into doing data analytics supporting litigation funders is because I practiced international arbitration at Freshfields during 2016 when they were debating about the legislative change. I was asked by the partner at the time to draft a memo about litigation funding, and I have been hooked ever since because it was so fascinating, so fast growing, and there's all the trifecta I like: data, there's law, and there's a lot of high stakes decision making. So really privileged and honored to be on this panel.
Great, thank you. So to get us started, my first question is, what forms does arbitration funding take? Perhaps, Dana, you could start, and then the others can chime in now.
Sure. I guess all funding and arbitration funding can take a number of different forms. Typically at high level, it's what funders do is provide non-recourse funding to claimants to enable them to pursue claims in arbitration. It also is it's a resource for claimants who are not impecunious. There are some claimants who make a business decision to use funding to support claims that they wish to assert in arbitration make a choice not to direct their money to litigation costs and rather use funding as a financial tool. And so, you know, in broad strokes, that's how funding works.
Isabel?
Well, I support their decision making in that process. So what I've noticed by working with international arbitration lawyers and funders is typically they wrestle with multiple stages of uncertainties when they're trying to make decisions. And international arbitration is fascinating for a use case of predictive analytics for two reasons. One is we start with investor-state arbitration analytics because it follows a pretty structured flow of arguments. And at each stage, there are only a certain set of arguments that can be made, and they all follow the treaty languages. And so I think when funders are deciding whether or not to fund an investor-state arbitration case, a lot of the decisions are driven by kind of, traditionally what's the ruling pattern of particular arbitrator. So we try to provide data and statistics to support them quantify those uncertainties, both at the stage of origination, picking between cases, as well as at the stage of underwriting so that they can have some metric to inform how do they quantify those uncertainties.
Nargis and Priti, can you perhaps tell us a bit more about how arbitration funding differs from litigation funding more generally?
Well, basically, I can point out 9 main characteristics that I have identified. First is the nature of the dispute. Mostly, our litigation is whichever area of law, whichever idea any lawyer can figure out. Arbitration is mostly commercial arbitration, commercial disputes, high-stakes disputes. That's the first difference that I can imagine. The second one is regarding confidentiality, Mostly all the issues that are discussed in public courts are public, All the litigation papers could be accessed by anybody, mostly, which maybe some specific limitations, but in general. In arbitration, the rule is confidentiality. Unless the parties agree to disclose the information, everything is sealed, and nobody knows exactly, even the award or this issue and discussion. The third one is duration, especially in arbitration. The average time for commercial arbitration is 3 years. Investment arbitration, average 5 or 7 years. In courts, depend the country, could last more than 5 years. Usually that's one of the advantages of arbitration. The other one is regarding, predictability. You have the big issue of predictability in litigation. You have precedents, mostly in common law countries, that in one way or another could tell you which could be the direction, but that's not sure. In arbitration, there is not mandatory, case law, not mandatory issues regarding, precedents, but in one way you could choose your arbitrators, and in one way you could realize in one way or another how they used to think, Other one is flexibility, When you go to courts, you got specific rules, the rules of procedural regulations and stuff. Rather, in arbitration, it's more flexible, There are the rules of the arbitration center, but mostly the parties could set the terms of reference of any arbitration and establish your calendar, which are going to be the procedural rules, etc. So it's more flexible, that's one of the advantages of arbitration. The other one is regarding, settlement. Settlement, obviously, especially in common law countries, most of the case settle, In arbitration, if you go to arbitration, there is not too much settlement until the end of the line, Usually, if you go to arbitration, there are few settlements, not too much, rather than in litigation in common law countries, Enforcement, obviously, local courts have to enforce their rulings. In arbitration, the big advantage is the New York Convention, where you can enforce your award in more than 150 countries, which is an advantage vis-a-vis litigation, because if you go to litigation, you have to follow up complicated procedures to recognize your ruling in other country. That could take years for that. The other one is regarding, cost. Usually, cost of the public cost of the litigation should be even lower in some countries, even it's covered, it's free, which incentivizes people to file claims in courts. Arbitration is costly, and that's one of the reasons, obviously, that litigation funding is an attractive alternative to this area, And finally, conflict of interest, Obviously, when you are a funder, you know who is the judge, and obviously there are rules to disclose if there is that mandatory regulation in each country, In arbitration, you have to check, if there will be a conflict that may put at risk your award if there is a nullification or not. Obviously, the most interesting party to keep safe your award is the funder. You never get involved. And as far as I am aware, has been never, a case that has been funded, that has been nullified for any conflict of interest of the funder and the arbitrators to rule that case. So that's the main 9 differences that I have identified.
Wonderful, thank you. Pretty.
Yeah, just to comment on a few of those differences and how they impact, the practical day-to-day work of counsel. So let's pick up on confidentiality, for example. You know that at the outset of an arbitration, the parties get together and develop a procedural order. If you're representing a claimant who is funded by a third party, some things to think about are, do you want to make sure in the procedural order that there is a provision that allows counsel and the party to share pleadings and documents that may be disclosed, what are the sort of contours of that, and to ensure that you are able to share those with the funder if that's what the funder requires. Another area that was touched upon was enforcement. Again, typically the litigation funding agreement will be between the client and the litigation funder. Typically, sometimes lawyers are involved, but for the most part, we try not to for ethical reasons. If it's important as counsel to understand what the budget is, and what happens if situations occur in the course of an arbitration, which always happens, that are not contemplated, that increase your costs. Who's going to bear the risk of that? Is there a cap on the funder's fee? Or do you need to provide in advance with respect to enforcement, whether the funder will be responsible for covering the costs of enforcement actions, for example? That's another thing to think about. In the area of conflict of interest, again, up front, when you're selecting your arbitrator, you're going to need to make certain, the arbitrator is going to need to make certain disclosures. What information do you need to provide to the arbitrator to ensure that they can assess whether they are in a position where they can take on the case? Do you disclose the fact that you have, that the claimant is funded and the identity of the funder? And I think the push recently is towards disclosing at least the identity of the funder so that arbitrators can confirm they have no conflicts of interest. So there are a number of these distinctions between litigation and arbitration that counsel representing claimants in arbitrations need to think about up front, even as early as the disclosure and selection of arbitrator stage, at the procedural order stage, to make sure that you think ahead to risks that may occur in the future.
I just would comment briefly on some of these points. I think they're all really interesting points, and it highlights some of the differences of arbitration from U.S. litigation. One of the issues that was raised is the procedure does not lend itself to obvious procedural times to discuss settlement. And that's been a criticism of arbitration, that there's no motion to dismiss stage. There's no summary judgment stage. And those are sort of inflection points in a U.S. litigation that, allow people to take a fresh look at the case based on the results of, any kind of motion practice and consider whether they want to settle. In arbitration, it's been encouraged or, suggested by some that we try to incorporate some of the dispositive motion aspects that are available in judicial proceedings into arbitration for a number of reasons: for cost efficiency, time and cost efficiency, to eliminate claims that really are not supported by evidence, but also to allow parties to have opportunities to recognize whether this is a good time for settlement. And some arbitral institutions are even adding to their rules regardless of a dispositive motion provision or window, that the arbitral institution shall have the right to reach out to counsel periodically and raise the issue of whether they would like to explore mediation. That's something that is not easily raised by any one party in an arbitration because it could be perceived, perhaps wrongly, but it could be perceived as a sign of weakness. So typically, if a neutral institution gives the nudge that settlement, mediation is always a good thing, and we're trying to resolve cases, efficiently, that is well received. And so I think that that's going to be something that I know the CPR Institute has recently incorporated that into their rules. I wouldn't be surprised if other arbitral institutions do that, because I think that what is so important about arbitration is that it is a private proceeding that is crafted by the parties, and party autonomy is critical to the success of arbitration. And party autonomy without a discussion of settlement seems like an oxymoron. So we need to work on that, I think.
Thank you. Isabel, I wonder whether you could tell us a little bit more about the contribution that predictive analytics can make.
Yeah, so we actually think about predictive analytics quite differently at Arbitration, maybe because of my background in stats and now in law. I'm slightly schizophrenic. I have a lot of respect for what lawyers do, but at the same time, we're probably the most pessimistic or realistic, whatever you call it, legal AI out there, in the sense that we don't think that we are just going to feed a bunch of documents and let the algorithm pick up what's most predictive by reading the documents and pick up patterns. Instead, we actually flip the process. We work with really brilliant advisors. So Donna's firm, for example, has been an advisor to Arbitration for the past year. We use the existing expert knowledge to inform us what kind of pattern and variables we should be looking for before even going to the data. Right? So we live in a day and age of deep AI and deep learning. We sometimes forget about why are we doing it? We kind of forget about the question of interpretability. And I think in international arbitration, where the stakes are so high, but then the data are so high dimensional, meaning that there are so few publicly available cases, but in the same time, the flow of the cases are so structured, it makes it for a very, very ideal testbed for crazy stats and scientists to really incorporate existing subject matter expertise and using those to inform and drive the inference questions in our model. So if we think of predictive analytics through that lens, then the contribution to arbitration sector is obvious, is that we are basically their data ninja, in the sense that they are constantly trying to quantify uncertainty based on their experience. But experience is often just an over-indexing of one's past exposure. And as experience as Donna is, and the cases that she has seen are probably just a subset of the case universe. So what we're trying to provide is kind of a quantitative second opinion to experts in the field, that whenever they want to ask a question like, let's say, how often is the Mazzini doctrine raised, and how successful was that argument before a particular tribunal, and does that probability vary if we substitute, the claimant arbitrator between Brower and, let's say, someone else. So we're trying to quantify those metrics to help them make the decision between, what they consider a strong case and a weaker case. Does that make sense? Am I making sense?
Thank you. Any reactions about the promise of predictive analytics? Is this the way of the future, or is this perhaps overhyped? Priti, what's your take?
I think it's growing. I think it is a combination of the two. I'm not that it's overhyped, but I don't think you can ever exclude the human element. And so it's interesting to hear, of course, you get sort of that perspective even as you're developing the tool. But ultimately, you've got to overlay. There is the very practical challenge of the fact that there are very few cases that are publicly available, but and information generally about arbitrators and how they decide is only now starting to become more available. So I think it is a wave of the future in that as that information, we amass that information, it becomes more available, then I think the ability of the tool is likely to be more accurate. But I think you can never sort of substitute. You've got to overlay judgment and instinct and all of that over it.
Narkis, what role do you see for quantitative analysis?
Well, so far my experience has been like you can make certain predictions regarding the length of a procedure, especially in arbitration. You can use something regarding doc review, but in general, in my opinion, legal disputes and arbitration cases are more like game theory in practice rather than decision trees. That's complex, and that's put an issue in order to try to get some predictability in the road ahead. So how you will be successful trying to quantify these issues of game theory put in practice, that would be great. But so far, I haven't been aware of that. But in my understanding, legal cases and arbitrations is more like that, like game theory in practice rather than decision trees in practice.
Do you want me to respond?
Sure, yeah, please go ahead. Yes, absolutely.
So I think we draw a distinction at Arbitration between what kind of predictive questions are best left for the qualitative judgment of a very seasoned attorney, like everyone here on this panel, and what kind of questions can truly use a little bit of quantitative support as the field evolve. And so I definitely take the point of as more data become available, the predictive insights will become more nuanced. But I think there is a misconception out there that just because the publicly available data set is so limited, there can be no meaningful quantitative insight drawn from it. We know that to be factually untrue because we just ran a modeling over the weekend using only 350 treaty arbitration cases. We split the sample, 280 for training and 70 for testing the prediction. And we only did like this one single thing, which is that a lot of arbitration practitioners would tell you, if you want to know how a case is going to go, look for the arbitrators, right? So the number one factor you look for is arbitrator. And there has been sort of, years of suspicion of some sort of arbitrator bias. And so we are like, so can we actually model that out and what that would look like? So we did this simple exercise, essentially observing this 350 cases, investment arbitration cases, and only looking at the arbitrator network effect and the outcome at jurisdiction stage. And if we baked into the model the assumption that the arbitrators are partisan, which is that claimant arbitrator wants the case to survive past jurisdiction stage and respondent arbitrator does not, and precedent is neutral in that decision, if we baked into the model that assumption, we already improved predictability by 20%. And we're just getting started. And so I think there's a misconception that in this day and age of big data, yes, big data can do a lot, but just because you don't have the scale of big data, you can do nothing. I do not, I don't think that's the natural conclusion. The flip side of that statement just is not true. There's a lot of meaningful insights that can be generated from high-dimensional data sets, and we have, PhD on our teams whose entire PhD thesis was basically specializing in how do you draw predictive inference meaningfully from high-dimensional data set. And law is by far not the only profession where they wrestle with this question, right? So in other industries, the question of how do you draw meaningful insight based on very limited data set is something that medical professions have been grappling with. It's not unique to law. I know lawyers like to think that we're very special. I think on some aspect we are, but when it comes to the statistical angle of what we're trying to do here, it's something that has been tried and tested in other disciplines, and we're just implementing that now in law.
Could I maybe ask Isabella a follow-up question then? So where do you get this data from, and what challenges, if any, does confidentiality raise to?
Yeah, so for the currently, the data that I just mentioned, that was just investor state arbitration. Anyone can get it online from ICSID or ITA law. The only thing we did was just we clean it better, and then we run a few models on top of it. The reason I started Arbitration was just really testing this hypothesis, right? Do we have enough publicly available data to provide some value first? But we are not limited to the publicly available data, because using the same method, we can help, let's say, White & Case clean their internal data set and generate insight just be available to White & Case, and whoever White & Case choose to disclose those insights to, maybe like funders that they work with. But we want to do something in the meantime before we have the negotiation power and leverage to talk to the White & Case and say, give us your data, we'll help you clean. We just want to do something that at least prove of feasibility, is a proof of concept, and we have proved that, and that's why I'm here.
Great. So returning to arbitration funding, Dana, you already started telling us about the benefits of arbitration funding. Could you maybe expand a bit on what the benefits of arbitration funding are, and who benefits from arbitration funding?
So arbitration funding can benefit both the claimant and the claimant's counsel. So some of the funding, let's just take a single case example. You could have a situation where the funder is funding the claimant and thereby, empowering the claimant to pay the legal fees of the counsel of choice, and that there's no compromise in quality and talent in terms of choosing the legal team. Often the relationship is such that the law firm that's representing the claimant will do part of it on contingency. So they might defer 50% of their hourly billables until the end of the case, and there would be a budget, as was mentioned earlier, and that budget usually has a cap. So the way it would work is that the law firm, on a 50-50 model, the law firm would receive, well, the claimant would receive, but de facto the law firm would receive 50% of its hourlies within the budget that it had prepared. And then at the end of the case, when the proceeds are collected, the law firm would receive a portion of that, and the funder would receive a portion of that as its return on its investment. So that's sort of a very basic formula for conceptually for how funding works. So, the benefits to the client and the law firm go beyond, I think, just sort of the pure financials. The issue of control has come up a lot today and perhaps yesterday, and I think that's an important one to address. It's sort of the elephant in the room, from a U.S. perspective and beyond the U.S., but I'm speaking for the U.S. Funders do not control the litigation. The client and the counsel of choice make the decisions in the case. I think someone put it well earlier in the day, the alignment of interests between the funder and the claimant and the claimant's counsel, all focused on putting on the strongest case possible, is important to a successful relationship that involves funding. as a funder and as someone who has 20 years of experience in international arbitration, I have just a few ideas that might help a litigation strategy. I don't dictate strategy, but I can be a sounding board, and I can recognize, from the earliest stages, how a case has been pled, and that helps me assess whether this is a case that really looks appropriate for us to invest in, and I can understand the procedural developments, and I think that that's a value not just to the funder, but it's a value truly to the client and the law firm to the extent that they want to, use that benefit. And I think that the connection, the conversation, the periodic check-ins between the law firm and the client and the funder are really productive to the substance of the case that's put on. Also, I would just say that sometimes there's a perception that the funders and the law firms are just sort of like, together and just having that conversation, and the client's like somewhere in the distance. Like, that's not really how it works. From my perspective, the funder has, regular contact with the claimant, for whom the funding is being provided, as well as the law firm. It's not sort of something that's done with the law firm and, the client's sort of like on the outside of that.
Great, thank you. So just picking up on a couple of points that Dana just mentioned, Narkis, I wondered what role, if any, does arbitration funding play on the government side in investor-state arbitration? Are there any instances where litigation funders provide financing to governments to cover their legal costs?
Yeah, well, this is a very interesting question. It all depends on the strategy of each funder. We try to be contrarian, and we prefer to work with governments rather than funding investors against governments. I can point to experiences, one in a Central American country where that country won an international arbitration against a big mining company, and the big mining company was trying to negotiate paying in exchange of continuing doing work in the country, And such award allowed this country, costs, 8 million. But they didn't have the money because the budget is based on each year. And sometimes you have gaps. And they approach, a group of investors and say, okay, why do you provide me the funding to pursue my costs? Or even start a publicity campaign, a PR campaign with the shareholders of such company in order to put pressure to the management to pay the cost, because already we won. And we are not going to be subject to the extortion of such company to exchange payment against continue doing work in such country. And was successful. They settled the case, And there are sometimes always, obviously, where, depending on the local regulations, they are more willing to discuss these issues. But my expectation is we are going to see more opportunities in that area. Theoretically, it's possible. Maybe there is complications from the regulatory point of view, depending on the regulation of each country, There is a political issue also, headline, risk. But, yeah, it's possible.
Great, thank you. Preti, so picking up on another point that Dana mentioned, Dana mentioned this triangular relationship, funder, client, law firm. What particular challenges does this triangular relationship raise in your experience?
So I think Dana mentioned the control aspect is a big question, right? And as counsel, your ethical obligation is to act in the best interest of your client, which is the client, not the funder. But the client's interests, in a sense, are aligned with the funder. The client may say, we would like you to keep the funder updated. We would like you to, and if the instruction comes from the client, then of course it's easy. No conflicts there, no issues. I think, in my experience, the challenges come where the client and the funder are not aligned. And typically it arises in a situation where the client feels we want to pursue a particular strategy. For example, we think that we need to add a third party to the arbitration. Not something maybe that was discussed up front, not part of the LFA, certainly going to add costs, but the client feels very strongly that well, we need to add the third party for enforcement and for other strategic reasons. So that's when I think as counsel, we're often sort of, the funder looks to us to get our sense as well. Although the funder is always, we tell the funder, you've got to get your own advice, and the funder, of course, very often will take independent advice. But that's an area where there may be some differences of opinion, and where we're kind of in between, and obviously pursuing our clients' interests, but also in a way advocating to the funder for the client. So that's sort of one area where very recently that's been my experience.
And just following on from that, what happens in your experience, Dana, if the client halfway through the arbitration wants to change the law firm and you have arbitration funding involved, does that raise any particular challenges?
So the client ultimately decides who its counsel is. These can be very complicated issues. I think to the point that, just one thing I wanted to circle back on, the triangular relationship. It's not, it's triangular in that there's three entities that are in a relationship, but it's really a relationship between each of the parties, a bilateral relationship within that triangle. So for example, a funder does not ask for and does not want anything that's attorney-client privileged between the law firm and the client, because that is an important attorney-client privilege that must be protected, and the way to protect it is to not have access to it. And so, the information that we have as a funder is information that's covered by a non-disclosure agreement that protects attorney work product and things other than attorney-client privilege. So there's a different set of information that a funder will have about a case. I'm sure you're going to have some thoughts on this. Than counsel will have on a case. And so, and there may be developments between the relationship, between counsel and the client that, we are not privy to, that could result in the client's decision to change counsel. In the first instance, where the relationship with the client and the law firm is good, the funder does, or at least we do, our best to support and maintain that good relationship, because we think that that's only appropriate to, that's their relationship. When there is a circumstance where the relationship breaks down for some reason, in the end of the day, it is the client's decision. And so I happily have not had that situation where the client has decided to switch counsel midstream during a case, but I do know that it can happen with or without litigation funding. I mean, these things happen. Or, another cost implication could be the addition of co-counsel. The case develops in a way where there's a certain niche area or expertise that it seems appropriate to bring in, co-counsel. And, that can change the financial dynamic of the case, but, the client needs to be represented as best as it can be, so.
Maybe a question following up from this to the panel as a whole. What kinds of conflicts of interest can arise in this context, and how should they be dealt with?
Well, one of the areas of conflicts of interest that has gotten a lot of attention is the issue of the disclosure of who the funder is, so that the arbitrators in the case can disclose any connections that they may have to the third-party funder. I think you've already mentioned that it's a rare case indeed in which these disclosures result in a change, but it is the earlier any disclosures are made in arbitration, whether it be about funding or any other connections that could possibly exist between the the parties, the law firms, the lawyers, and the arbitrators. It is absolutely incumbent on anyone to disclose it as early as possible so that any steps can be made, to step down or recuse or whatever. So that, I think, to avoid conflicts of interest, that kind of disclosure is very helpful.
Yeah, and it's far better to have, there's pros and cons. The reality is that you make a disclosure up front, you're the claimant, you may invite a challenge, right? And that in and of itself can prolong the dispute. Frivolous challenges are not unheard of, especially in the investor state space, and so there is that sort of downside. On the other hand, from the funder's perspective, you don't want to invest a ton of money into a case only for a conflict to come out, close to the award stage or after you've had a successful award, and then your award could be subject to annulment. So for the most part, I think people have supported the idea of early disclosure for that reason. There are other, I think the classic case is, as Dana mentioned, arbitrator has a relationship with the funder, maybe sits on the advisory board of the funder or any other relationship. Less common, but also another scenario that has been discussed is this idea that you're Mr. Say Nargis is sitting as arbitrator on a case, and his partner, Dana, is in another case, and in both cases, in Nargis's case, the funder is funding the claimant, and then in the separate case, the funder is funding Dana's client. That's another situation where it's far, more murky, I think, but there is potentially an argument there that Nargis is benefiting from indirectly the funder and his relationship with Dana. So that's another area where conflict could arise.
Thank you. Nargis.
Yeah, just to comment from the regulatory point of view of arbitration, I mean, the main arbitration centers, there is no specific regulation regarding disclosure of third-party funding rather than anyone who has an economic interest. Could be a funder, could be a bank, could be anybody. That's the first issue. The second one, there is only one arbitration center, and it's located in Brazil, that has established a guideline recommending the disclosure. Recommendation, not mandatorily. It's up to the arbitrators to decide. And obviously, lawyers try to use that as a guerrilla tactic to say, okay, I'm going to involve the third-party funding, who maybe I can have here a new, angle to discuss or something like that. But so far has been rejected. So as a matter of principle, there is these guidelines of, the ICC, the IBA rules, the International Bar Association has very clear rules regarding the yellow, red, green stuff. And so far it's working well, because as I told you, there is no such, I am aware, any case that has been, nullified because any conflict of interest between, the arbitrators and the funder. It's the most important thing that any funder cares. We don't want any possibility that they may discuss such issue.
This point might be a little bit besides the point, but my observation, just by having drinks with funders in Singapore, sometimes they actually prefer disclosing because then it kind of scare the other side away. I've heard anecdotes of that, and so I don't know.
A strategic element to disclosure, okay?
Yeah, no, absolutely. Particularly, you're a claimant, you want the arbitrators to know it's very difficult to get third-party funding, right? It's just a very small minority fraction of cases that the funders, after doing extensive due diligence, believe are worth funding because of the high prospects of success and the value at stake. Yeah. And it is always, I think, as a general matter, useful to let the arbitrators know, hey, we've got a funder backing this, and that means we've got a strong case, obviously.
So it sends a signal that your case is, relatively speaking at least, stronger.
Yeah, and it's very interesting one issue, it has to be with bias. I was talking with one top arbitrator and he told me, I prefer not to know that you are involved, because then I will have a bias that obviously you are in the side of the most strong case, because not only is an extra due diligence than the lawyer of the case, but you have put money on the table. So I don't want to know that, because my bias will be that you are probably the most strongest case between the two parties.
So, if we are in favor of disclosure, does that mean maybe disclosure should not be to the arbitrators, but disclosure should only be limited to others? Are we in favor of mandatory disclosure? Dana?
Well, I don't purport to recommend any legislation or anything of the like
Yeah.
on mandatory anything. I do think that there are certain parts of the world where this is already a non-issue, and it has been legislated that if there is a funder involved, that the funder identify itself and allow any conflicts of interest to be flushed out. There's practice in much of the world of international arbitration, irrespective of any kind of mandatory rule that arbitrators will ask if there's funding. And you know, I think that the majority of people discussing this issue feel that the concern about potential conflicts is such that even if it may, tip the scale slightly in the eyes of the arbitrator with respect to the strength of the claim at the outset, that it's important to flush out conflicts issues, and the case is young, and the arbitrators are going to be impartial and independent, and I do believe that, notwithstanding your metrics. And so the background presence of a funder, is I don't think in the end of the day tainting the way that an arbitrator is going to view the facts and the law.
Some arbitrators are statistically more independent than others. Let me put it that way.
So, UNCITRAL is discussing in the context of the reform of investor-state dispute settlement this week in New York, third-party funding, and there seems to be growing concern about funding. Do you share some of these concerns that have been expressed in that context? Preti?
I think we've talked briefly about some of the benefits, right?
Yes.
And I think that in terms of increased access to justice, in terms of being able to allow claimants who wouldn't otherwise be able to pursue certain claims, third-party funding is beneficial. I think where we see a lot more debate is in the investor-state space, and part of that is part of that is just the fact that investor-state is such a polarized field to begin with, and you have people on very different sides of the spectrum, given how politicized it is, and there is a sentiment that it's making what is already a very dysfunctional system, I'm using that in quotes, even more dysfunctional because it's increasing the number of claims against state parties who, there are exceptions for sure, as Nargis mentioned, but for the most part, they are left out of the equation, right? They are almost always respondents, and for the most part, they're going to be sued rather than have the ability to get funding to present a counterclaim, for example. So I think there's concern, particularly in that space. But I don't think that means, to some extent, I think that's part of the discussion and debate about how do you regulate investor-state arbitration and how do you make it a more level playing field, not necessarily unique to third-party funding.
So this is very much part of the broader concerns about investor-state arbitration, the alleged asymmetry of it.
That's how I see it.
Yes. Nargis, any thoughts on this point?
Yes, I guess this backlash regarding investor-state arbitration has two explanations from my point of view. First is some excesses of arbitration boards regarding damages. It has been a lot of theories, and obviously you can build any model, and the economists and the financing guys could explain any type of damages. And sometimes arbitrators were more tempted to award expected damages with many different theories. And that got a resistance from the states because the bill was growing and growing, you know. If you are more focused in sunk costs, it's great. No resistance, you know, it makes sense. It's impossible to discuss if you are doing an expropriation or something that is affecting sunk costs. And the other explanation that I have of this new interest regarding, you know, came from Europe now. In the past, the majority of the claimants were, you know, American investors and European investors against, you know, sovereigns in Latin America, Africa, Asia. Now it's the other proposition. You know, there are now investors suing Spain, Germany, you know, Italy, and now obviously such states and the academics of such states are building this, okay, now we have to talk and change the rules because now we are being sued and we don't want that. We want now even something that has been like anathema in arbitration, which is a second stage. You know, usually arbitration is one ruling and that's it. Now they are proposing that for state investor dispute, you have a second stage. So I think it's a matter of what the timing, you know, the issue of damages and the issue of who is being sued now, who is like an explanation besides that, and all this discussion if it is good or not to have a second stage rather than a final award.
Yeah, so the tables have been turned and
Yeah.
developed countries have woken up to the potential downsides, and that provides much of the explanation. Dana, any additional thoughts on this?
So I don't know that the UNCITRAL Working Group 3 sessions in New York this week, April 1 to 4, have actually done as deep a dive on any of these issues as we are discussing today. I think that the issues that had been raised before were raised again. I wasn't in the UNCITRAL sessions, but I wear a lot of hats, and one of my hats is president of Arbitral Women, and Arbitral Women has delegates attending the UNCITRAL Working Group 3 sessions this week, and so I get some reports in that way. And really the issues that we've been talking about were really outlined at a high level, you know, whether third-party funding should be prohibited altogether, whether it should be defended and championed because it is an avenue to justice and allows claims that would otherwise not be made, you know, at a high level, whether it should be regulated, and if so, that whether the regulation should focus on the transparency and disclosure of who the funder is and stopping there. The issue of how to regulate or how to sanction or deal with a failure to disclose was raised, but it wasn't fully discussed, but that's one of the issues. You know, the proposed amendments to the ICSID arbitration rules that, you know, a second working group paper came out just in the last few weeks that focuses on disclosure of the funder for conflicts purposes. And I think that these are all issues that are going to need to be discussed in further sessions. I understand that there is planning to have further sessions of the Working Group 3 in Vienna later this year. It also, one of the issues raised in the paper submitted by UNCITRAL, circulated and discussed this week, is the issue of costs in arbitration and security for costs, and whether third-party funding should or should not be considered with respect to those issues. And there are arguments on both sides, and I think that the ICSID rules do not, you know, the proposed ICSID rules do not make that connection without more. Third-party funding in itself is not a basis to ask for securities for costs, but any application for securities for costs is a fact-specific, fact-intensive case in each arbitration. And I think that, you know, whether it goes to the propensity of certain arbitrators to lean in favor of states, certain arbitrators on the investor side, these kinds of sort of, high-level kind of generalizations break down when you go to the fact-specific case in front of the very arbitrators who need to decide the case. So I think that these are all concerns at a high level that need to be talked through, but I don't know that every single concern is implicated in every single case, and sometimes there's a confusion in that.
Thank you. So Isabel, you mentioned earlier that for the data analytics that you carry out, you collect, of course, data. And so I wondered whether data protection legislation, and I was thinking particularly about the General Data Protection Regulation.
Oh, yeah, we just went through the GDPR compliance
So how does that affect
exercise.
Yes.
Absolutely. Well, I think it affects everyone. So because we sell to law firm, and so the compliance are particularly strict. Cooley is one of our earliest believer and earliest clients. So even them gave us a 280 question compliance survey. It's a combination of ISO 27001 certification. That's why I hired a Google CTO to deal with, and as well as GDPR. I think GDPR is an important concern, but not so much in what we do, because what we do, we work with lawyers who are already deeply concerned with confidentiality and data privacy. So we're not gonna use any data that our clients have not felt comfortable upfront. So we're not like consumer tech where you build a platform and then you sell access to the client's data to third parties. We don't do that, and so.
But I understood that you are collecting data on arbitrators, for example, right?
From publicly available investment awards, right? So, we don't do anything beyond that, right? So going forward, if I can imagine a scenario where a global law firm invited us to help them understand their in-house data, but if we were to be invited in, that consent is already, being that would be the premise of that collaboration. So we don't really go beyond what is publicly available for our publicly facing analytics platform. And we do not sell access to our clients' usage data of our platform to any third parties. And I don't think anyone's interested in lawyers' usage of legal research platform, to be honest. There's nothing they can sell to you based on that pattern. So the stakes are pretty low in what we do.
And how about litigation funders and law firms? How are they affected by data protection legislation in this space? So thinking about data on arbitrators that may not be always in the public domain.
We are very protective of, obviously, in a big firm, inevitably you're going to have sharing of information. You're going to have central repositories of information because you can leverage the experience of your colleagues. But we don't, when we do share that, it tends to be on a case-by-case basis, and it tends to be in a way that is, we're already protected by the cloak of privilege vis-a-vis this client, and we're telling you, here's our experience with this particular arbitrator. We don't tell the client, well, this arbitrator sat on these specific cases and discussed these specific issues and decided in this way. That's not the way in which we would present it to the client. It would be in a way where we're preserving sort of the confidentiality of each of those individual cases. But I can't think of a situation really where we communicate with the outside world in a way where we're not, it would be rare where we're communicating with the outside world in a way where we're not protected by privilege and confidentiality. So I think it's less of a concern.
How about on the arbitration litigation funder side? Is that an issue that you've encountered?
I haven't encountered this from the funding side. That may be a reflection of the fact that I'm one of the newer entrants to the funding world. I do know that in the world of international arbitration from sort of the practitioner standpoint, and I'm by no means a GDPR expert or, I just have to tell you right now, that is not my field, but I have learned from people who are experts in it, and the focus really is Europe and data in Europe and data leaving Europe and being sanitized and so.
So I think the sort of scenario that I was thinking is you have, say, an EU citizen who sits as an arbitrator and who asks a litigation funder, asks a law firm, disclose all the information that you have about me, or delete all that information. Is that something that you have come across already?
An arbitrator asking a litigation funder to disclose
all data the litigation funder has on this particular arbitrator. I have a right to my information.
I haven't.
That's not something that you've.
That's just not something that I've encountered.
So I wondered whether you could each tell us where you see arbitration funding in the case of Preti, Nargis, and Dana in sort of 10 years' time, and Isabel, where you see data analytics in 10 years' time. Preti, perhaps we can start with you.
So I think that it's become much more the norm. 20 years ago there was a bad smell with arbitration funding, and now, it's very common, ubiquitous. People coming out of law school are hearing about it. Back when I was in law school, I don't think we had it was mentioned, but I don't think we ever had a course on it. I wouldn't be surprised if 10 years from now there is. I wouldn't be surprised if there are far more job opportunities for young lawyers coming out to work with funders, and that it becomes much more part of our daily fabric. So I think that's sort of the direction in which it's heading.
And thanks in no small part to this conference, of course, also there is growing awareness among students. Nargis.
Well, I guess the next big thing will be secondary market transactions. All these 15 years has been mostly devoted to raise funds to cover costs. Now it's going to be the other way around. Okay, you have the cases already are funded, so you're going to sell part of such cases. So it's going to be a big market, not only in institutional level, but even though it's going to be down, small claims. And that will be the second big thing, will be securitization. Any industry starts like that way. First, you create mortgages, then you sell mortgages. And the real estate industry works that way. Litigation is going to be the same. It's going to be a big secondary market, a big opportunities in that market, and the issue of securitization, for sure.
Thank you. Dana.
Well, I'll just circle back to the warm welcome of our funding in the arbitration world that, I will say this since I'm not White and Case, but the Queen Mary White and Case report that came out for 2018, which you were modest enough not to mention, it recognized the responders to the survey, 97% of the, if I'm right on that statistic, it was 90-something% of the responders were aware of third-party funding, and over half the responders had a, quote, positive view of funding. So in the international arbitration space, funding is farther along in the spectrum of being accepted and viewed as, a constructive tool in a positive way. And so the debates that we are having about, when should disclosure happen, and to what extent should there be regulation, I don't think that it should escape us that in fact these discussions are happening because in international arbitration, funding has been prevalent and welcomed for a long time, much more so than in some other sectors of dispute resolution.
So arbitration funding has very much gone mainstream and has entered the center stage in the world of arbitration.
And I would add also to that, I think, certainly Europe and the US, but also increasingly so, I think, in Asia now, with Hong Kong having changed its rules, Singapore having changed its rules.
Absolutely.
So these sort of former common law and Commonwealth countries where you had these antiquated doctrines previously of Champerty where, you couldn't have it, it was illegal. There's much more receptivity now.
Where do you see the biggest growth opportunities for arbitration funding in the next 10 years? In which regions or countries?
I mean, my sense is that it's going to grow in the regions where arbitration is growing. So China, the Belt and Road Project is of huge interest to a lot of people. Central and East Asia, are areas where there is expected to be growth, and I think we'll see arbitration funding growing as arbitration grows in those areas.
I also think that the litigation arbitration funding has been largely focused on the investor-state treaty arbitration, and that's most visible because those are, to some extent public proceedings, or their existence is public, and often the result is public because it's on the ICSID website or other publicly available, sources. But in the private commercial arbitration setting, there's a lot of arbitration work that still isn't being funded. And I think that is in an area of growth in the future as funding goes from, not just funding a claim because the claimant can't otherwise pay to prosecute its claim, but as funding becomes used as a financial tool by sophisticated multinational corporations that have cross-border disputes and joint ventures that are, ultimately resolved in arbitration, in a private commercial arbitration, you're going to see the big companies using funding for, cash management purposes. And I think that's going to be a big area of growth.
And Isabel, where do you see data analytics in 10 years' time in the
Well,
arbitration space?
I think for me, I'm going to say something that's slightly more provocative. I think international arbitration is a multi-trillion-dollar asset class, and it's only in the beginning of that trend. And if we think of it as an emerging asset class, then I think increasingly the decision being made would be more data-driven, and the decision turnaround cycle would quicken significantly over time. And the quality of those decisions would be more and more, nuanced and sophisticated. Would be a combination of quantitative and qualitative expertise. So in that context, I think data analytics going forward, I think we're right now in this transition place where we were so in love with AI and deep learning and machine learning, and then just starting to realize actually we can't throw the data into machine learning model and then just have that be the final answer. I think we're just starting to realize that how harmful that kind of approach is, and we're in this transition trying to figure out how do we walk the balance between computational efficiency and the deep interpretability of statistical models driven learning, right? Because machine learning, at the very heart of it, is statistical learning, right? So how do you infer a pattern from, existing data, but then that question cannot be answered by data itself. It has to be answered and driven by some sort of causal inference and causal hypothesis, and then we turn to data. So I think my prediction, if I have to make one without referring to data, is that data analytics will become towards a more measured place where there will be increasing attention paid to the underlying model driving those AI and the choice of the AI that we use, and what is it that we're trying to answer before turning to big data. So I think there will be increased focus on interpretability, coherent uncertainty over the benefit of just pure automation and deep learning and black box prediction. So that's my humble opinion.
Great, thank you. Well, I think that's an excellent concluding remark. So please join me in thanking our panelists for their insightful observations. And I hand over the floor to Robert for some concluding remarks.
Thank you so much for this panel. Thank you, Professor, for moderating, and thank you all for who stuck around till the very end. I think this is a big step for our organization, and kind of our take on this industry has always been kind of the combination and the potential for technology. So thank you for kind of portraying that view as well. And we'll be here again next year. We've gotten so much support, and we're incredibly grateful for that. So thank you all, and I hope you have a great time with us.